Well, hello, everybody. I think we can get started here. It's 1:30. I'm Glenn Pasowitz. I'm the Executive Director here at Joint State Government Commission, and we're providing the staff support to the Election Law Advisory Board. Just wanted to let everybody know up front, we are recording the meeting, and it is being live streamed on our Facebook page. And also to give everybody a reminder that if you want more information about the board, background information and such, that is on our website. And we will also have a link to the recording of the meeting on the website as well. With that, I just wanted to say that, get that out of the way real quick. I'm going to now turn it over to Chairman Lawrence, and he can call the meeting to order and call the roll, and we'll proceed from there. Thanks.
Okay, good afternoon, everyone. This is Ken Lawrence, Montgomery County Commissioner and Chair of the Election Law Advisory Board. Thank you for all joining us for this April 8th meeting. I am going to call the roll. I apologize in advance for any mispronunciations. And I can see a lot of you here, but we'll call the roll. Glenn told me to do it. So I'll start with our Vice Chair, Commissioner Cantz.
Present, Mr. Chairman.
Okay, Patrick Christmas.
Present.
Amy Kazi.
Present.
Okay, and Jesse Daniel, I believe, is not going to be able to make it. Right, okay. Commissioner Deely.
Present.
Representative Diamond.
Present.
Commissioner DiGirolamo. Okay, I know he was leaving early. Maybe he's coming late and then leaving early, but Commissioner Erb.
Present.
Mr. Houston. Okay, Ms. Iacano.
Present.
Commissioner Cutts.
Present.
Commissioner Lohr.
Present.
Mr. Marks.
Present.
Okay, and I know Mr. Moran has had a sudden loss of his mother in the family, so if we can just send our condolences to him, he will not be present today. Mr. Sembach.
Present.
Mr. Smith.
Present, Mr. Chairman.
Ms. Spitzer.
Present.
Mr. Zeppi.
Zeffy, present.
Zeppi, I got it now.
You got it.
Senator Tartaglione.
Present.
Mayor Urschler. All right. Commissioner Vogler.
Present.
All right. And Mr. Wenger.
Present.
All right. Thank you all. And with that, I'll turn it back to Glenn, who can start to lead us through. I want to thank the staff for all the work that they've put into based off the survey, and looking forward to getting into the agenda.
Okay. Now, what we want to do is follow through with the workbook that our staff has been putting together on this as the place to get started with our discussion. So, Yvonne, if you have a starting point there with the workbook, and then we'll proceed.
Hello, everybody. Welcome back. Quick disclosure, if you see me squinting or looking beady-eyed or whatever, I had a retinal detachment 2.5 weeks ago. I had surgery a week and a half ago. And so my vision isn't quite what it should be. So if I sit there and it looks like I'm winking at you, I'm really not. But saw my surgeon yesterday. Everything's doing fine. Everything's recovering appropriately. This is just apparently a very long recovery process, which I am not a very long recovery process patient person, but we will get there. So anyway, enough about my daily travails. What we tried to do with the workbook is pick the issue that seemed the most dominant issue in the survey, and one that we could kind of address in whole without it flowing over into a lot of other topic areas that could get us going down a million bunny trails. So what we wanted to start with is basically the concept of pre-canvassing and kind of follow a logical procession about if that's going to happen, how it should happen. And one of the issues at some point I think we're going to want to deal with is what to call it, because pre-canvassing itself is a term that doesn't mean a lot to a lot of people. Most of the states we looked at do not use that terminology. It's really only used in Pennsylvania's election law in the section that talks about pre-canvassing, and then it's used like less than 10 times. So that's a definition we're probably going to want to look at eventually. But one of the basic rules of legislative drafting is do your definitions last, because that's when you'll be able to see what you really need to specify and detail. So the first issue in general is, and I'm hoping we can get some quick consensus on that, or we may be done for the day, is that there should be some period of time prior to Election Day when absentee and mail-in ballots can be prepared for processing. Whether or not that actually includes counting the votes is a decision to be made down the road, and those kind of specifics are things we'll get into later in the discussion. But the fundamental question is, should there be that time period before Election Day where ballots that are received before Election Day can be processed in some way? So that's the first question. I think one of the things we heard, and I think Representative Diamond, you may have mentioned it in an email the other day, is that was one of the issues that came up in the state government committee hearings on a regular basis, that a lot of people felt that was something that needed to be addressed, that there should be some kind of period. And from our perspective, if that's going to be the case, then we want to spell out in detail how long that is, what you can do, what you can't do, and try to be as clear as possible on what that's going to involve. So talk amongst yourselves. Some form of pre-canvassing is appropriate.
Yeah, my only concern, I don't have a problem with pre-canvassing, and it is by far the biggest ask we've had on state government committee. My only caveat about that is that a voter whose mail-in or absentee ballot is received, there's got to be some sort of two-way communication between the County Board of Elections and the voter, so the voter has an opportunity before Election Day to either confirm or contest whether that's actually their ballot. And you know, I just came out of a hearing with Wendy Underhill from NCSL and another young lady. She said, you know, we do have those problems all across, and it's rare, but sometimes there's a voter who shows up, you know, we've got them, and they challenge it, and after the fact, it's like, well, yeah, that's not your signature on that ballot. Even though it's rare, one voter disenfranchised is one voter too many in my eyes. So if we can work out a system that's pretty much foolproof as much as possible, because a lot of this stuff does happen because voters can be elderly and can be forgetful, you know, that sort of thing, and I understand that. So as long as there's some sort of robust two-way communication between the county board and the voter to have an opportunity to confirm that before the voter may show up on Election Day and cast a provisional ballot that may get thrown out, I don't have a problem with it. But, you know, as long as we can do that, and I think everybody would be in agreement that you would want every voter to have a fair chance to make sure that the mail-in ballot received in their name actually was their vote. That's the only caveat I have. Because once it's pre-canvassed and separated from the envelope, you can't reach into the pile of secret ballots to pull out the one that is offset by their provisional ballot. That's my only caveat.
Yeah, okay. And I think that's something we can, one of the details we can address as we go through how are we dealing with these ballots as they come in. I'm sorry, I can't understand what Moto Z means, but you're right next to Representative Diamond. I thought you were trying to say something, so I want to give you a chance to respond. No? Okay.
If I could,
Actually,
is
if
there
I-
anyone who's opposed to pre-canvassing? I mean, can we have, not, I know the devil is in the details, but is there anyone who would be opposed to that there needs to be some level of pre-canvassing?
The only thing that I believe that we have to be careful of, this is Commissioner Lohr from Fayette County, is that once again, it goes into the fact of personnel inside the building, inside of our election bureaus. We have to be very cognizant of the fact that we don't have personnel to handle the load when we keep on putting more on them to get the jobs, task oriented. We can't get it accomplished. So that is one thing we have to definitely keep on the very edge of the table every time we make a decision on anything, including pre-canvassing. So that's a tough part when it comes to pre-canvassing as far as the personnel once again.
Well, and that's a topic that I expect us to get into in future meetings, is how to address the shortage of poll workers, the amount of training they're receiving, the whole concept of having an election manual that people are trained on and know what they're supposed to be doing as they go along. But part of that too, and some of the legislation we've seen introduced thus far, does talk about how are you paying those people? How are you getting those extra warm bodies in there to assist and get them qualified to do the work? So that, again, gonna try to deal with this more in the abstract, and then get into how are we gonna get people lined up and trained how to do it. So otherwise, I think we can go around in circles for a long time trying to figure out, well, if we do this, then we'll have to do this. So I think anything we say we want to do here, and one of the nice things we can do with our reports as they come out, to the extent we have any legislation in them, is to explain those caveats, write about those caveats, because that is something that can then be used by the judiciary to interpret what the intent of the legislation was. So I think we can progress carefully and making note of all those related issues that we also need to resolve as we move forward. So, okay.
Well, I think those related issues are going to be key because, as the chairman just said, the devil is in the details.
Absolutely.
And I think the three key issues are security, if they're opened early. Secondly, chain of custody, if they're untallied. And then lastly, but not least, is what happens if results get released early.
I think those are all very valid, and we do talk about some of them as we move through the progression of the workbook. So hopefully we can address some of those, because those are all incredibly significant aspects of the thing. And in my own humble opinion, I think the probably most problematic one in terms of addressing it fully is the early release of information. Because how do you stop people from talking? And so I think that's one that we're definitely going to have to spend some time looking at. Were you going to say something, Joe?
Yeah, Yvonne, Mr. Chairman, if I might, obviously I've been pushing harder for pre-canvassing than any other issue. There was one, and to be fair, in the one handout that we received before the meeting in preparation, the ELAB recommendations, ballot prep and ballot counting, one of the issues that I had not given thought to before, and it's a very fair concern in all seriousness, is number 3B, and that is the counting of ballots of someone who voted but is now deceased before Election Day. That's a very tricky situation that we will need to address as we talk about pre-canvassing. And I'm not sure I have an answer for that problem, a solution for that problem, but that is a very valid point. And just as Representative Diamond said, we don't want anybody to be disenfranchised, but we also don't want someone's vote to count that's not any longer an eligible voter. So that's just one thing we have to keep in mind. I mean, I am absolutely in support of pre-canvassing as many days ahead as we can get it, but that is an issue we're going to have to think about.
Well, and that, there's a section of the election law that addresses that I'm hoping to put the statute in front of you guys at another meeting and look at it and really talk about how do we verify who is still a qualified elector in those days leading up to the election when they may have already basically purging the rolls in whatever way you go about doing that. I mean, there is statutory language there, like just about everything else in Title 25 and in the election law. It probably needs to be clarified. And that is also an issue that's come up in some of the pending legislation in Pennsylvania that we've been looking at, is how do you identify those people? So yeah, I mean, it's all going to be related, but we'll try to, you know, we're going to try to get to the things and at least note what ties in with what, if that made any sense at all.
If I may just interject there, I mean, this is related to what Commissioner Cantz was talking about. We just got word yesterday that a court has ruled that the Department of State must remove 21,000 deceased voters. And so we asked the Department of State through the committee today, if we could get a list of those 21,000. What the Department of State told us was they're not removing those voters until after the primary is over. And there may be a federal law issue or a statutory issue that prevents such voters from being removed within a certain time period before an election. So that may be related to Commissioner Cantz's concerns there. So we may want to look into that.
Absolutely. We can.
Yeah, this is Jonathan Marks. I just want to clarify that we actually, the department entered into a consent decree with the litigants in that case, and we've agreed to use the ERIC deceased voter data and do a one-time comparison against the SURE system using the ERIC deceased. So that whether the list is 21,000 or something else, I don't think we actually know what that number is yet. Because we have to do that comparison with ERIC. But I think that was, I apologize, I'm on mobile because we have a meeting out in Grove City tomorrow, so I'm out here in Western Pennsylvania, just checked into my room. But I think that was Representative Diamond. The one thing, and we have actually suggested this to the General Assembly before, and we're certainly happy to work with him. I know he has some legislation that he's proposed to streamline the process, not only for the Department of Health to get information to counties, but we'd also like to open up this ERIC program option to counties. Right now, the election code limits what counties can use as source of deceased voter information, and it would not include, the language is not broad enough to include ERIC deceased voter information we get through the Electronic Registration Information Center, which is ultimately coming from the Social Security Association. It's verified information, it's official information, and we'd really like to give counties that tool on an ongoing basis.
All right. So I guess if you look at issue 2 that we outlined, what should the early processing entail? And I think I tried to put this in something regarding a logical order, but we'll see. If you guys want to jump around in here, I think that's not an absurd thing. But and some of it is very fundamental. I think if we're pre-processing, yes, we're going to open the outside envelopes. Where do I have that? Oh, and then maybe it should have been before that. The verification of signatures on the absentee and mail-in ballots, and the matching of voter information. Those are the kind of things we would normally expect, from our perspective anyway, that would be something that would be involved in the inspection of the ballots when you open them. So I guess part of this, do you open up both envelopes? Do you pull the ballots out and flatten them, for lack of a better term, to be able to scan them through the machines? How much do you inspect them? How long a challenge period do you allow? What is your challenge procedure going to be? Are you going, how are people going to be allowed to cure ballots? And then are you going to count those votes in the pre-processing period, or are you going to reserve them until election day and count them when the other ballots are counted? So having thrown all of that out there, and then the last question in the section is, if you are going to open them and verify them and allow people to cure them and everything else, how are you then going to keep those ballots secure from the time you process them until the time they're actually counted on election day? So I will throw that whole bundle out there.
Yvonne.
I see.
Yvonne, Randall Wanger, if I may, just real quickly, so we don't go off on the wrong foot here. As a former election director, the inspection of the voter signatures should be done the day that the ballot is returned to the County Board of Elections. That's not part of, and should not be part of, what would be considered a pre-canvass or early process part. That should be done, verifying it's the voter signature that's on the back of the ballot, that it's a reasonable match to the record and SURE, is done as the barcodes on those envelopes are scanned into the SURE system to record the ballot as being returned. And that is also what in this last election generated emails to voters through the Department of State system, those who had applied electronically, letting them know that their ballot was received. I see that as a completely separate and standalone issue to be done within 24 hours of receipt, and not at all part of this process. Once you've checked them in, then it's up to a voter to raise a challenge as to the legitimacy of that ballot. Otherwise, it gets opened. So that I don't think belongs where we have it in the outline here. But if I could, just as a practical matter, that goes first. And then on your other topics more generally, if I may, the answer to this is going to depend on when do you want results. If you want results on election night by 11 o'clock, you have to do everything before election day for those ballots that have arrived before election day. If you're okay waiting for several days, then, but to be quite frank, it's pointless to only open the outer envelope. Once you've opened the outer envelope, there is no tying that ballot back to a voter. There's no removing it in case the voter's deceased. Once you open the outer envelope, you should go all the way, in my opinion, including scanning it in, but not releasing results.
Hi, this is Commissioner.
That makes sense. Yes.
It seems to me that a lot of these concerns that have been raised, both in this meeting and the meeting before and in the emails that I'm reading, I think one of the best tools at our disposal is to do some research into best practices. Although we are late in the game, there are a lot of states around the country that are doing this, and they all have different options, and they could answer a lot of these questions for us or give us some details and some explanations for us to make a more quantified decision as we go forward. So I think one of the things that we might want to work on is making a list of concerns to then research, because we are late in the game, but we really don't need to write a brand new playbook. There are best practices out there that we can use to help us along the way.
I guess my only concern with that is how they're identified as best practices. Some of the things we work on, some of the projects we've worked on, there will be a central repository of what's considered best practices.
Well, even if it's not a best
That's the only thing I'm a little hesitant about, and we are continuing to look at other states, and I'm sorry.
We don't need to call it best practices, but my point being that they are doing this in other states and have been for a while. So it would be beneficial to us to do some research and see, how other states are doing it. I would also say, I tried to get in earlier, but we should be careful not to make more mandatory, put more mandatory unfunded mandates on counties. So whatever we're doing, we should try to keep it optional or give it a time frame or some reasonable solution, so that we're just not throwing another unfunded mandate on counties with regard to elections.
Well, Stephen has looked at some of the pre-canvassing stuff in other states. Obviously, there are a number of states who are looking to do things now, and we're following them. But I think the takeaway, and correct me if I'm wrong, Stephen, is that other states are all over the place, that there isn't necessarily one thing that anybody's doing that is like, oh, everybody's doing that, and then there are some outliers. They're almost all outliers, even if you look at the time of the ballot preparation. You go from California and Florida that give you like 3 weeks, almost a month to do it, to some states that you can do it the day before election day. And then other ones, what state was it, Steve? They take the ballots out of the envelopes and then they throw them literally in a barrel and pull out ballots one at a time. I forget what they were doing with them when they were doing that, Steve. You recall? You got to turn your mute off.
Sorry about that.
That's okay.
Yeah, I know what you're referring to. I'd have to identify the particular state that does that. I'd have to come through here, but I know that they were attempting to mix them up for purposes in their procedure. I can take a look through here and find out which state that was, but
that's not necessary. What I'm proposing is that there are answers to a lot of these questions, like deceased voters, and how do other states handle that? It is worth a look, just to see. There's probably bad, things that we wouldn't ever want to do, but there might be some little bit out of here and a little bit out of there that makes sense. Thank you.
Oh, sure.
One of the things that you mentioned in your comments there as well, that I think there are probably some on this board that maybe haven't had the pleasure or the opportunity to experience an election day in a courthouse. And so, first of all, before I forget, one of the things that we've done in my county is invite our entire state delegation, since they're not on the ballot this primary, to come in even for an hour on election day and see how the process works. And if they're so allowed, I know they're checking on it with legal, we'll even have them help open the ballots if that's what it takes. I mean, I think it really changes your perspective when you are actually a part of that process and get to see what happens. So that's number one. Number two, one of the things that you mentioned, and I know was on some of our pre-meeting notes, talking about the tallying of the ballots. I know this is a controversial issue for many, but as somebody who does this every election, or at least, with the new machines, the past 2 elections, I really don't think it should be that controversial. The only way someone can take results from a large scanning machine, we have in our county 1 person that has access to that machine, and they are directed by the county board of elections to lock down those results, so no results can be seen until after 8 p.m. on election night. There's 1 person that has that ability. The commissioners don't have it. The board of elections don't have it. Only our elections director is given that authority. If we can't trust our elections director, then put penalties in the law that are so horrible that an elections director would want to go to jail if they broke that law. You're always going to have a human element in an election. And the only way you can have a problem with the human element is if someone is dishonest. So the question comes down to, do we trust our elections directors or do we not?
Well, then,
I'm gonna just add one thing to what Commissioner Cant said. Each of the systems that are used in Pennsylvania do have the capability you can scan the ballots without actually tabulating them. So you could do everything during the pre-canvass. You could even scan them through the central tabulators, but until you actually do the tabulation or run the report, the person who's scanning them isn't going to know what the totals are. So each system has that capability. And I know that's how some states do deal with it. They allow the scanning, they just don't allow the tabulation.
That fact will be key because as we've discussed potential amendments to the election code, this question has come up over and over again. And there's 2 issues here. If you don't scan and you open ballots early, you have paper ballots sitting around, and that gets into the chain of custody and security and everything else. And there's a fear that ballots will appear or disappear. But doing the scanning, and as a number of people on this meeting will testify, I have asked this question over and over again to reassure people that if it's scanned, there's a record, and that record cannot be accessed until the appropriate time. And when it's accessed, you're then able to verify that the number of ballots cast and the results match. So this is key, and it's going to be an education effort because we have faced it over and over and over again. If you scan, what does that mean? And again, there's the fear of ballots appearing or disappearing.
If I could just quickly about some of the information Randall brought up, just as an election director who has frantically tried to open and scan ballots and get it completed on election day. If we're going to allow additional time for pre-canvass, to just open the envelopes is not helpful to us. That is not going to get you, it's mildly helpful, but pulling those ballots out, flattening those ballots, backbending them, that's what takes the bulk of the time. If you're not able to take those ballots out and flatten them and prep them, it's useless having a pre-canvass. And then to speak on the tabulation portion of it, I would prefer to be able to scan those ballots in as they're being opened. I don't know if you've ever seen 85,000 paper ballots in person, but it's a little overwhelming. So it's nice to be able to do all of that work completely as you're going through it. And like they said, all of the equipment in Pennsylvania has the ability to keep that tabulation, those results, private and secret until 8 p.m. on election night, when here in Northampton County, I myself take those USBs and I put them through our election management software. And at that point, I report the results. So certainly if you said you were going to charge me with a crime, I am not willing to go to jail to give somebody results. That would be enough of a motivation for me, and I'm sure my colleagues across the state. So I think this whole notion of releasing results early is a little silly because it doesn't happen, and nobody's counting results as they're opening envelopes either. It's just not possible. So I don't think that should be a deterrent in when we allow people to start the pre-canvass.
So that's what I'm hearing is from Ms. Cozy and Mr. Wenger. And this is a good thing because you're bringing your real life experience and understanding of how this works while we're coming in looking at from our perspective, looking at a statute and saying, how does this work? So what I'm hearing right now, what we need to do is if we're going to allow and everybody seems to be in agreement that we should have a pre-balloting process, and it should go from start to finish up to and including scanning those ballots, that we go back, look at some of these other states to see how they lay this all out, and prepare to send out to you a quasi draft, because I don't think we're ready for legislative language yet, of how it would work if we were going to put it in a legislative language from start to finish with those issues in, and then allow you to come back and say, yes, I like this. No, I don't like this. These are how it goes, and include some alternatives based on what look like good ideas coming out of other states. So I think from that perspective, I think we have some more work to do from our end. I think the next then more big general question is, how much time do you want to give?
Yvonne, let me actually say something first.
Okay, sure.
And I'm probably I have a feeling I might end up being a minority on this. I've been around the elections since '94. I know I didn't get elected until 2015 as a commissioner, but I've been around the elections since 1994. And the ballots, the absentee ballots at that time used to go to the polls where they could be challenged. The names could be challenged legitimately and pay the price, do everything needed to be done. They never got opened until after the election. They were tallied after the election. All the candidates knew that this was just basically a luxury vote. It wasn't even the accurate vote, which we all know, just even dealing with last year's election, no one really had a tally for how many weeks after the election anyways. I think we're opening up a huge can of worms by doing this kind of stuff from the public arena, because I've already had people say to me, well, I didn't know that that person even voted, and I would have challenged them at the polls if I would have known they were at the polls. And as the one director said, as far as the names being verified, the signatures being verified, in 1996 here in Fayette County, there were names challenged in a personal care home, and one in particular. And we had to have writing experts to come in to verify the signature, and found out that the signature was wrong, but it was cleared at that time in the polls and the absentee ballots. So when we're talking about all this stuff, I think we're opening up ourselves a huge can of worms when it comes to tallying votes, opening votes, things of that nature on even election day or before, because of those kind of things. We can verify who's mailing them in, but I think going beyond that is, in my personal opinion, a mistake, because it does question the voters themselves. At least that's what I've gotten on the street over the years. And I apologize for background noise. I'm in my car.
Hi, Yvonne, if I could.
Please.
This is Andy Zeppi. I'm county solicitor here in Allegheny County. I'm one that lived in a warehouse with 353,000 mail-in ballots last election. And I second everything Ms. Cozy said about that system. It's, if you can't flatten them and count them, you've saved, around the edges. I think one thing we have to keep in mind with regard to challenges, that whole system changed under Act 77 and 12. You can challenge at the application stage based on whether someone's a qualified elector, but that's the limit. That's the only basis to challenge a voter. So we live in this world where Act 77 kind of still acts like things are done in person at the polls, which it's not. Those ballots never go to the polling place anymore. They all go to the central location. I will say one thing that always occurred to me throughout this process for the group's consideration is that, you know, there's a whole world of states out there that have early voting. I'm not saying that's another topic for another day, but those votes, if you're alive and well when you go vote, as I understand it in those states, Ohio, Florida, that's it, your vote counted. If you then die 2 weeks later, the day before election day, your vote's still in. You were alive and well when you voted, your vote counted. Because the system, finding the needle in a haystack, going through the reports that we receive from the medical examiner's office at the last minute of someone who dies, really, really hard to do, especially when you have 353,000. And there's a provision in the election code now that says, look, if it's too late and someone died at 6:50 a.m. on election day, their vote still counts. And that does not negate any election results or anything. That's in the election code now. One thing to think about, if we're going to go with an early, it solves the problem of who dies. I mean, if you're alive when your ballot's received and you're counting them as they're received, you got yourself a vote. I don't know, that makes a lot of sense to me as someone who was boots on the ground doing it. It eliminates that need to go fish them out, which doesn't really particularly make much sense to me. We pretend your vote was cast on November 3rd this past time, but really you filled it out and mailed it in a month, 5 weeks earlier. I don't know. It's just something to think about for the group's consideration, because from an administrative standpoint, my experience was that would be a lot easier. It kind of negates the whole issue of what happens if you die later.
If I could make a couple points real quick. First, Commissioner, you mentioned the issue in 1996. We had an absentee ballot issue situation in Philly in 94, I believe it was. Those were both before we had voter ID rules for mail-in ballot application and absentee ballot applications. The only portion of that 2012 voter ID law that remains in effect is for absentee mail-in ballots. So that's a fairly strong safeguard that we already have on the applications that we didn't have, in the early 2000s and 90s and before that. The only other point I wanted to make real quick is to bring it back to what Randall opened up with, that it makes a great deal of sense to go ahead and examine that envelope on a rolling basis as these things come in, and for a couple of reasons. I mean, first, whether or not that barcode scans appropriately, correctly, and then whether or not there's a signature, you guys can go ahead and code that in the SURE system. A voter can be notified right away, which is obviously good for that voter if they made a mistake and they did a sign thing. And then on the integrity side, Representative Simon makes the case that we have to have real-time these ballots. If that's something else that helps there. I mean, we have noticed right away as the ballots were received, and this has been mentioned in other states. If there's a handful, I mean, I think in the hearing we just had this afternoon, the former official from Colorado mentioned there's like single digits, the number of ballots that show up that looks like were not returned by the voter. They can flag that right away, and actually in Colorado statutes require that those few, very, very few instances are passed on to law enforcement authorities. So just wanted to flag that. I thought really good point that Randall made, which is to separate that examination of the envelope earlier on, and then we can figure out the time about extraction, flattening, scanning, etc.
Yeah, and Pat, to add to your point, very valid reason. If we don't inspect those signatures and the barcodes when the ballots come in, everyone that works in elections office knows that we will get inundated with phone calls from every voter saying, did my ballot get back to you yet? If they didn't get that response in an email through the system. The amount of unfunded mandate that creates has not been calculated in most of our figures.
Ms. Cozy, I apologize. Can I just follow up with a real quick question? And this can be directed to anybody on the panel who knows more about the mechanics of these machines than I do. You had mentioned that nobody is doing it. That is to say, nobody is accessing the votes that were cast before Election Day. And that you said, I think you said that nobody was capable of doing it. When you say that, when I hear that nobody's doing it, and that's offered for a reason not to create safeguards against it, that's not as convincing to me. But hearing someone say that it's incapable, that they're incapable of accessing these records, that gives me a little more peace. So is there anybody on the panel who can speak to whether it's a possibility, whether these machines are able to be accessed to pull out the votes in advance of Election Day?
ours is passcode protected. So if I'm going to run a report to get results, I, one, have to know the passcode. I also would need all of the results from we have multiple scanners in our county. So one scanner is not going to have the entire county's results on it. It's going to have the results from whatever ballots were ran through that machine. So it is a matter of being able to have the passcode to pull the results report, and then to also access the election management software, which is where those results come together and are totaled and tabulated and ready to give to the public. So that's something that only somebody at my level here in this county, and I'm sure most of the counties across the state, would be doing.
Is your access to it using that passcode recorded?
There are logs of everything that happens with the central scanner and how it's been accessed, yes.
Yeah, I'll add just a few comments to that as well. So it maybe sort of backing up just 2 weeks before the election. I mean, the way this works for not only the precinct tabulators, but also the central tabulators that counties use, they go through pre-election testing. And once pre-election testing is done, they're locked, they're sealed with tamper evident seals to actually do the tabulation. As she mentioned, you have to put in a passcode. So all of this remains locked and sealed with very limited access all the way through the canvass until the votes are tallied. And then you do the post-election testing and reconciliation to verify that the status quo didn't change at any point between the completion of testing and the completion of the tabulation of votes. So it's a very tight chain of custody. When I worry about, potential risks, I worry more about the physical security around the ballots themselves than I do about the election machinery. And those can be mitigated too, and there are already election code provisions to mitigate them. But I think the machines and the tabulators themselves, they're thoroughly tested. The counties do their pre-election testing, and then they're locked and sealed. And if somebody does tamper with them, the county's going to know it.
Okay, so if we end up coming up with a way to do preparation in advance of Election Day in a form that everybody can live with, how much time do you think is an appropriate amount of time to do this? Like I said, we've seen everything from starting the day before Election Day to 3 weeks in advance. I think probably the average has been more in the 7 to 14 days range, but do any of you have a feel for how long you think would be an appropriate amount of time to be able to do this?
Well, not to get political, but prior to the election, we looked hard at providing for a longer pre-canvassing period. And I will tell you, every day you go before Election Day, the lift gets heavier. So whether you do 1 or 21, the question is, are you ultimately going to get the support to go beyond or before Election Day? So, and that's where all of the other provisions come into play, that we've been talking about. Chain of custody, security, early result of results, all of that comes to play. So whatever number you pick, at the end of the day, if you're going to make a change, it comes down to whether or not you have the votes. And the counsel I would give on this is, every day you go before Election Day, the lift gets heavier.
If I could just tag on to what Fred just said there. I mean, the lift gets heavier, not just here in Harrisburg, but I would think that the longer you go before Election Day, the lift gets heavier for you at the county, because this is a demand on personnel and resources. And what I've heard now, and this is kind of like aimed at the county commissioners on this board, is that you want the pre-canvassing, and there is demands on resources and personnel to do that, but you don't want unfunded mandates. So we need to strike that balance when we're crafting legislation here, because we want to give you what you want, but we don't want you to come back at us and then say, well, you gave us an unfunded mandate, because we don't have unlimited resources. And it really comes down to this. Convenience always comes at a price, whether that price is financial in resources to do this extra counting, or whether it's the price of waiting a few days beyond Election Day to actually get your results. It's like, what price do you want to pay for the convenience? I've been trying to talk about that, on the floor and in our discussions. It's like, let's remember, this all has some sort of price tag, whether it's time or whether it's money. So we need to keep that in mind as well. And I will, Fred, remember when we first had House Bill 2626, the original pre-canvassing period in that was 21 days. And then that got worked down, that got whittled down to, I think, 3 days before it finally died over in the Senate when we knew the governor was going to. So it's that kind of trade-off that we got to talk about too.
I would just say in the Senate, they won't do anything before 7 a.m. on Election Day. We tried over and over and over again to give you guys more time to be able to start this pre-canvass, and it was dead on arrival. That's something we have to look at seriously.
If I could just paint a picture of what Election Day looks like when you're trying to conduct the 2 elections that we now have to conduct simultaneously, because I'm hearing about resources, and it's much more taxing on my office to process mail-in ballots on Election Day while simultaneously conducting an in-person election. To get results in November within 24 hours, I had to staff 60 people just to open ballots. And my entire full-time staff that knows the election inside and out, they had to stay in the office because they had to be the ground support for our poll workers and our voters. So I didn't have them with me. I was also pulled all day long because I'm overseeing the canvass. I'm not here overseeing the in-person election. The longer that we are given to pre-canvass, and I'm not talking 3 days, because the 3 days before the election, we're finalizing our poll books, we're getting election equipment out, we're getting supplies out to our poll workers. We have very limited staff to be able to do those things. We need 7 to 21 days ahead of time, because now we can do these things in small batches. I can pull 3 of my staff members instead of trying to find 60 people in the county to open envelopes. And we can do this in smaller batches, more methodically, very thoughtfully, and we're not trying to cram everything into a 3-day time period. And you talk about after the election, we have a lot of things to do after the election too. We have to start the canvass by Friday. We're going through the provisional ballots. We're meeting with our election board, all of those things that have to go on immediately after the election. And election week is long. We're talking about 90 hours our staff works. I worked 36 straight hours in November. It's very, very difficult on the staff to try and do all of these things in such a short period of time. So the longer you give us, the more you're going to ease the burden on the election staffs around the state.
Ms. Cozy, you're preaching to the choir here because we went 21 days. I'm from Philadelphia, so I'm sure Commissioner Healy can tell you how many people she had to put on and how many days of sleep she missed. So I know the longer we can go for pre-canvassing, the better it is.
So thank you, Senator. And to Mr. Zeffie's point, I also lived in the convention center with hundreds of thousands of mail-in ballots. So I have a real good idea of what it looks like and what it means. But I think that if we can look at that 21 days and we make it optional so that counties can start when it makes sense for them, both by election and just by staff. So what Philadelphia looks like might be different, and what their needs are might be different in an election than Fayette County, for example. So if you're 21 days and you make it optional, and counties can then do what makes sense for them, I think that, that's one thing that we could look at.
And I think too, certainly the expectation is now that people want the results election night. I don't think we're going to recondition people now to wait. We tried that, and I don't think it works so well. So, I was saying last October that I'll take as many days as we could get. But I don't know, to Amy's point, I don't know that 3 days gets that much because there's so much else going on that people don't understand. We were functionally running 2 elections, or really 3 elections, because we haven't even talked about drop boxes or anything like that, where we had to start accepting ballots a lot sooner. So I understand Fred's point completely that each day it might be more difficult, but I would say, 3 days, I don't know what difference that really makes in a presidential election when we had over 200,000 ballots in Montgomery County.
And just one other consideration, to get to the 3 days in House Bill 2626, and this is another consideration, 2 provisions were added in, one of which would change existing law, the other which would be new, and that was the delivery of ballots to election officials. There was a requirement put in there that ballots had to be delivered by 2 a.m. the day after the election. And then the current provision that allows the canvassing to begin 3 days after, that would have been changed to 9 a.m. the day after. So as you're talking about adding days up front, there's also consideration as to what that means on the back end when you're required to start. And then, of course, that becomes a mandate on the counties as well. So it's all a balancing act. And the question is how best to get there.
I offer a follow-up question, Ms. Cozy, and maybe Mr. Zeffie, if you could answer this question. Is it right to think that finalizing the poll book is a prerequisite to being able to examine an envelope coming in containing a ballot?
No.
Okay.
No, because like we mentioned earlier, we check in every ballot as it comes in. We do that verification as the ballot comes in. We don't finalize the poll book until, the Friday or Saturday before the election.
Right, I totally agree. We scan them in now into the Sure system that generated the email to the voter already. And then, right, exactly. Maybe the weekend before poll book finalized. So there were 9. Go ahead.
Oh, I'm sorry. I was just thinking, like Joe is from Snyder County, much smaller place. Is this as much of an issue for your election officials? I mean, what Commissioner Deely was saying, to me personally made a lot of sense, that depending on what your county's needs were, should drive how much time you have. And I'm just thinking about some of the smaller counties, if this is as much a need as, say, Philadelphia or Pittsburgh or someone like that.
Well, it's a great question, Yvonne, and it goes to Amy's point, and that is the fact that we are running 2 simultaneous elections. And for, it all based upon size. In Snyder County, I've got 2 full-time election staff members, 1 to do voter registration and my elections director. So you can imagine how many people we had to pull in from outside of our elections office just to do, in our case, 6,000 mail-in ballots during a presidential election. I can tell you that every single one of our commissioners stamped over 1,000 envelopes to send out ballots. We had to help open all the ballots that came in. I mean, we had to spend $11,000 like most counties on a letter opener, high-speed letter opener. Some counties have multiple units. And to Representative Diamond's point, I would argue that, yes, while I don't want to pre-canvass opening envelopes on election day, the other part of that is I don't want to do them too soon before election day either, because I want to make sure that as many of those mail-in ballots have come in as possible, because I don't want to have to take the stragglers, if you will, and do them on election day. Now, we will have some, but I don't want to have to do any more than necessary. Having said that, I agree. I think that your larger counties, when you're processing hundreds of thousands of ballots, you're obviously not going to get them done in 3 days, especially with all that has to be done to get ready for the live in-person election. So maybe it's a staggered approach. Hey, we do staggering for other things with counties of different class sizes. Maybe this is one of them to take a look at.
This is Dan Vogler from Lawrence County. It's interesting because we've heard from some of the very largest counties, and of course my colleague from Snyder County is one of the smaller counties in the Commonwealth. Lawrence County is unique in that based on the last census, we fall right about in the middle. About half the counties are larger than us and about half are smaller. We have a population about 90,000 residents. And in consultation with my director of elections, I know he has indicated that the probably a good time frame for him at a county of our size would be about 7 days. And it does kind of fall in line with what I'm hearing. I hear the larger counties obviously might need more days than that. And so I just wanted to add from the perspective of what I would characterize Lawrence County being a medium-sized county. Thank you.
Thank you.
So in Philadelphia, every county has different equipment. We have 12 scanners, 22 extractors. So the scope of an election is different. So smaller elections, we're probably in a better place than, most counties. But when we look at larger elections, that we're challenged. But if you look at a small election, like Snyder County may not need to start until 7 a.m. on election day, where we may need 3 weeks, right? So that's why I made a suggestion that if we look at the 21 days and we make it an optional choice, something to think about. Thank you.
We can definitely go back and play with that from our perspective. Shifting gears a little bit, because I think I know what we have to do from our end to move forward with this for you guys. Let's talk about watchers. My understanding with some of the problems in Philadelphia was that COVID restrictions very much compounded the problem and the ability of watchers to be present and be able to effectively see what was going on. The current statute, I guess the question is the current provisions governing the role of watchers and how close they can get and what they can and cannot do sufficient, or do you feel it needs more clarification?
I just want a point of clarification. Philadelphia County follows the current statute with regard to watchers.
Okay.
I think the one thing, Yvonne, to think about when we use the term watchers, we got to be careful. Watchers only exist on election day at the polling place, poll watchers. At the canvass and pre-canvass, there are authorized representatives, and those are very, very different things with very different legal rights on what they can do. So
should they be? And I think that's one of the questions. Should there be regular watchers, or should they be representatives if we're going to start and processing and counting ballots in advance of election day? Should that role of the representatives be more aligned with being a poll watcher?
It's conflicting in the election code. They use both terms in different places. But so just for point of clarification, the people that were there to examine, we followed the code.
Yeah, we have to remember too, the watcher stuff was born out of the time, before mail-in balloting, right? Everybody went to the polling place and you could say, I walk in and say, I'm a Vaughn. They go, whoa, 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 that's not a Vaughn. I'm challenging that voter. I'm a watcher, pay the money, whatever, and then off you went. You challenge that voter. At the canvas, in our case, in a warehouse, there are no voters,
That's
right?
true.
So you can't come in and challenge a voter, and under the current Act 77 anyway, you can only challenge their application based on whether they're a qualified elector anyway. So
Okay.
it is already set up as those two being very different things. And I don't have a problem with it the way it is. It worked fine. I think there was some sense among authorized representatives that they were watchers and could come in and start saying, I'm challenging this, 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 and this. What the authorized representatives can do is go to election court like they did in Philly when they said we want to be closer to this, that, or the other thing. That they always have that option, but they are not able to challenge a voter. There's no voter there to challenge.
Okay.
Yeah, there seemed to be some sense that they could examine signatures and information, and that is just not the case. So the current statute allows them close enough to see what they're doing, making sure they're not stuffing ballots in their pockets, and that's really all they're there to observe.
Okay. I think that's part of the question, is because there was, at least in the popular media, I think some misconceptions about what was going on during the last election. And so, and that's coming from our perspective then, is this an issue? Is this a problem? Does it need any kind of fix? Or maybe we just need to write in our report that these are two different positions, and in just a narrative form, clarify that a little bit.
I think what we saw with that was just a misinformation campaign that just went on throughout. I don't see a problem with it right now.
Yvonne, I don't know the answer to this, but one of the questions I had is, did Act 77 allow for out-of-state representatives to be in county courthouses in Pennsylvania? And if so, I would argue that we need to change that. I don't think that we need to have out-of-state. I have no problem if you're in any county in Pennsylvania and you want to be in my courthouse to watch the results, but why would we want to allow out-of-state people? It just doesn't seem quite right.
Out of county people were permitted if they were members of the Pennsylvania Bar Association.
Is that statutory with members of the bar? Is that a statutory thing?
Yeah, if they're counsel for a campaign or a candidate.
Oh, okay.
If you're a poll watcher, I forget if you have to be in the state or in the actual county or in the precinct, wherever, that's a different, you meet a different set of criteria to be a poll watcher versus being an authorized representative.
Okay.
Yeah, I think the issue is that, the term authorized representative was added to the lexicon, but the election code doesn't define it. And the provisions related to absentee and mail-in balloting, I don't think puts, unlike watchers at the polling place, where it clearly defines what the authority of the watcher is and what the limitations on that authority are. That's not necessarily the case with authorized representatives who are entitled to be present at the pre-canvass or the canvass. Now, that the election code does define a little bit attorneys and other authorized representatives of candidates, but not much more. Watchers are more well-defined than authorized representatives. So it might be something that the committee wants to look at. Do we need to define or at least provide for the, authorization or limitations on that authorization in terms of what they can and cannot do during a pre-canvass or canvass proceedings. I did want to point out, just to kind of give it context, when we're talking about watchers at a polling place versus authorized representatives central tabulation, it goes back to, I think, the election code treats them differently because the circumstances are different. When a voter goes to vote in person, first-time voters are required to provide ID, but anyone who has voted more than once in that precinct is not required to provide ID. So it makes sense for in-person voting that a watcher may have the ability to challenge an individual who presents themselves in person to vote. With absentee and mail-in ballots, as Mr. Christmas pointed out, since 2012, there is an ID requirement, a driver's license or last four of SSN, during the application process for an absentee or mail-in ballot. If those numbers don't verify, the county can still issue you a ballot, but in order for that ballot to be counted, you have to show up at the county Board of Elections, or you have to provide to the county Board of Elections another form of authorized ID before your ballot can be counted. So every absentee and mail-in voter is providing ID during the application process, whereas in-person voters, it only applies to first-time or voters who are voting for the first time in that precinct. So the two are different circumstances.
Okay. I think what I think I heard Joe Cant saying, and I guess a question that we might want to address is, especially in a national election, a presidential election, that a representative of the candidate could be someone from a national campaign, a national political party who's not a resident of Pennsylvania or a registered voter in Pennsylvania, showing up to the courthouse and the poll. And is that something that you want to restrict, that should an authorized representative be a qualified elector in Pennsylvania, a resident of the county or the, I think precinct, at least in some of our more rural areas, that would be hard. You might be hard pressed to find somebody like that. But should there be a limitation, some kind of residential or election district or some kind of parameters on who can be those authorized representatives, especially from like a national campaign?
Yvonne, let me give a little context very quickly on that. The reason I brought that up, one of the gentlemen we had at the courthouse during the pre-canvass on election day this past November was a very nice gentleman. We had a wonderful conversation throughout the day because he was here all day long. He was an attorney, but he was also a county commissioner in another state. So they're used to doing things much more differently than we do here in Pennsylvania because of their election laws. And while we had, like I said, a great conversation, we exchanged information and hopefully we'll stay in contact with one another, there is that educational process, and it took a lot of my time away from the day to explain the differences in the law and the things that we do here in Pennsylvania based upon our law. While I'm more than happy to do that, I'm not more than happy to do that while we're pre-canvassing 6,000 mail-in ballots. So that's why I bring it up.
Mm-hmm. No, and that makes at least sense to me. Anybody have some thoughts on that? Pat?
Yvonne, I was going to add, I think this makes sense that they be a Pennsylvania elector and observe the ballot processing, anywhere in the state. And of course, like whenever that process starts, the observer should be present. And further, like what they're there to do is not to challenge every, little signature or date on a ballot, but rather if they think there's a procedural or systemic problem, they seek relief in court. And to Joe's point, I'm sure almost everyone here who was in that space processing the ballots had to do the same thing, which explain the rules over and over and again. And something they do in other states is to have a training and certification process. I'm sure the counties would prefer not to do that, but sure there could be a state level training and certification. It doesn't have to be super extensive, but like a base level understanding of what the rules are. Because I know that was a time suck for a lot of our folks, but maybe everybody who was in these spaces.
I'd like to second that from Pat. In the in the hearings that the state has been having, they had Pam Anderson from Colorado actually came over, and in discussions about the observers, they actually have specific laws that allow for training for those observers. The observers must take that training, and the code also empowers the election officials to remove observers if they do not adhere to those training regulations. I think that something like that would be beneficial in the code for PA.
Okay, any other thoughts on things we should keep in mind as we look to try to provide an outline of some language that would allow ballot preparation and processing before election day? I'm trying not to use the term pre-canvassing because in conversations with several of you, it's been my understanding that term does not fly. It does not work well for people. So, yeah, if you have any other thoughts on things that we should be looking at and should be paying attention to as we try to pull together for you to review a process and some proposed language that would create this process in Pennsylvania.
If I could just throw one more topic out there for at least brief discussion. I mean, because one of the questions here is around, ballot curing. I think, the way this already works is when these ballots come in and get scanned, I mean, that triggers an automated email through the SURE system. So good for the voter, doesn't require additional work for the counties. In other instances in the code, when there's an issue, like when someone applies and doesn't have the appropriate ID, they're sent a hard copy notice as well. And I think in most other states where there's a cure process, that sort of cure affidavit is sent out to the voter to correct that issue. So, for example, if a ballot were returned without a signature, I guess they could fix that one of two ways. Either they could go to the election office and sign a cure affidavit there, or one could be sent to them and then returned. So I put that out there for brief discussion, and it's not. I mean, it's not a huge number of ballots, but I think it was at least 7,000 or so, or somewhere in that range that was rejected in the general due to a missing signature or perhaps a missing ID. I know naked ballots or dressed ballots or secrecy envelopes we're dealing with separately, but at least on that issue, some number of folks are not getting their votes counted.
Well, I don't know if this is helpful or not, but last session's House Bill 2626 had a process, and last session's Senate Bill 10. I don't know if it's helpful or not. We thought it was a good starting point to address the issue, to give some assurance that people were who they said they were when they were casting ballots. So it may be language you want to look at. I'm not pushing it, but I'm just saying it was something that was discussed at length and did end up in legislation last session.
You had to bring up the naked ballots.
Sorry, there were too many memes flying around last.
That is one of the more closely related issues to ballot preparation with mail-in and absentee ballots. If they come in and they don't have all their envelopes, maybe we could have a little general discussion on what some of you think we should do about that.
So I'm sure everybody knows that I am very much in favor of eliminating the secrecy envelope, as it is a vestige of the past, and it does indeed just one more hurdle to get those ballots counted, and it can be easily replaced by a more secure outer envelope.
From Allegheny County's perspective, we share that opinion. It was meant for the days when they were opened at a polling place by your neighbor, not at a centralized tabulation location warehouse where no one knows who you are or cares who you voted for. So I agree. It's just another hurdle that causes problems. Not to mention the fact whether you have it, then there's the whole issue of whether you write on it. We had people whose votes didn't count because they literally wrote, "My name is Pat Christmas, and I really, really want my vote to count. My phone number is ... Please make sure this gets counted." And under the law, and what did they really do wrong? You know, what did they really do wrong? I'm allowed to walk into a polling place, vote, announce my vote to the whole world, and my vote counts. Doesn't matter. Doesn't matter. That's my business. I think
While you're wearing your candidate's T-shirt.
Well, technically no, but yeah. The point is, I agree that it's just an anachronism that should go.
And from an administrative standpoint, we in the office, anytime a ballot is rejected for any reason, we have the pleasure of going back and we have to scan those ballots in as being rejected. They don't just get tossed into a garbage can somewhere. So voters are getting notified that their vote didn't count and they have questions about it, and they'll call and ask, and you say, "Oh, well, your ballot wasn't in the secrecy envelope." Well, this is the one rejected reason that we don't have any tangible evidence of. They can't say, "Well, prove it. I know I put it in the secrecy envelope." We have no tangible evidence to show them. We can't prove that they did indeed not put it in the secrecy envelope. And I think if voters are going to be disenfranchised, we should have a tangible, producible piece of evidence to show them why. With every other reason a ballot gets rejected, we have that. If there's a missing signature, we can produce that. If there's an issue with the application, we can produce that. All of these things we have a paper trail of. This is the one thing that we don't, and I think that's a really big problem.
Yeah, I mean, I think we did a very effective job of communicating to people that they needed to use the secrecy envelope, to the point that some people returned their ballot with the secrecy envelope and not the outer ballot. So I think it's a relic, and I don't know what it accomplishes except for disenfranchise people. Just one more step, and another complication for our election day workers too, when they're handling the ballots.
So I fully understand your reasoning for wanting to get rid of the secrecy envelope. However, the Constitution requires that we have a secret ballot, and it's not just secret from Aunt Mabel who's working the polls in my neighborhood. It's secret from anyone. So how do you get around that constitutional provision that requires a secret ballot if you get rid of the secrecy envelope? Unless you're opening and extracting the ballot inside some sort of dark tunnel machine that nobody can see.
And I agree with Russ Diamond's concern there, not only the constitutional concern, but there's a difference, Mr. Sethi, in the analogy you created where you're walking in announcing to the world at a polling location, "I'm voting for so-and-so." Surely nobody's going to stop you from making it to the poll and in secret doing whatever you want there. Whereas in a courthouse somewhere, they're going through, or a warehouse, they're going through the envelopes. It's there to protect someone who sees who you are from disenfranchising your vote because of who you are. It's likely to never happen. And again, it goes back to this, the arguments that it never happens aren't persuasive to me. What's persuasive to me is that we have steps to protect it from happening.
We are scanning those ballots and opening them at such, with this equipment, that nobody is seeing whose envelope that is. It's going through an extracting machine. Everything is happening so fast. If you put that ballot in a bank envelope, it's secret.
If I may just add a component from the primary from last year, prior to the Supreme Court weighing in on this, all but 2 of Pennsylvania counties deemed that a voter's failure, and some version of this, but that a voter's failure to include the secrecy envelope was a voluntary waiver of their right to a secret ballot and opted to count them anyway. And that of 65 of 67 counties in the primary opted to take that approach. And then obviously over the summer, the PA Supreme Court had the issue brought to them from and they ultimately ruled that it was a fatal defect and those ballots couldn't be counted. I'm not arguing, I would not argue for eliminating those ballot secrecy envelopes that the county sends out, and I certainly think there's a good constitutional reason for it. But I think if we defined the failure of using the secrecy ballot as a voluntary waiver of the secrecy of the ballot secrecy, just like voters do when they apply for and submit a UMOVA ballot, where they're signing that they're voluntarily waiving their secrecy. Failure to include the secrecy envelope, I think, would make more sense to have it viewed as a voter or defined as a voter voluntarily waiving their right to a secret ballot, as opposed to a reason to have that ballot not be counted at all. And as I can second Amy's comment of the explanation, I mean, when I got these calls last November following the general election, it was a joy to tell people that, yeah, you signed your name to it, because at least I had proof of their autograph on their secrecy envelope, as opposed to, no, you had no secrecy envelope. Yes, I did. I know I did. No, you don't. It's here in my hand, or it's not here in my hand. But there, it did not put counties in a pleasant position. But I do believe the constitutional right to a secret ballot is very real and does need to be respected. But I guess the question becomes, someone's failure to do that, should that keep their constitutional right to vote from counting, or is it better to view it as the voter has voluntarily waived their right to a secret ballot? And so I'll let it up to the legal folks to determine whether a voter can waive that right, but folks can generally waive just about any right and opt to. And so that would perhaps be a way to look at it, to still require it to be included. And I think it does potentially not as much of a role as it served once you did it out in the polling places, but there still is some benefit to it. But, not counting a ballot because it's not there doesn't put counties in a great position. Certainly creates voter angst, and ultimately they're folks that are registered and eligible to vote, and they missed the technicality, and now we're in a position where we need to throw those ballots out. And I do believe the law as it's written does require that, but obviously we're talking about changes at this point.
Randall,
Randy, I can appreciate that argument, Randy. Thanks.
Yeah, Jim and Russ's point too. I completely understand both sides of the issue. One potential solution might be, to your point, Randall, what if there were a checkbox on the outside envelope that says, I have waived my right to a secrecy envelope. So we know beyond the shadow of a doubt that they are acknowledging, I don't care if it's in a secrecy envelope or not, I'm waiving my right to that.
Unless they don't include the secrecy ballot and don't check the box.
Right.
Someone will do that.
Yeah, I think the issue here is, what if you didn't send them the secrecy envelope? I mean, there's a lot of different reasons why somebody may not include the secrecy envelope. One of them may be because a county forgot to send it to them. You're assembling packages. It's not out of the realm of possibility that occurs on occasion. So I don't know that we need to overcomplicate it. I guess the question, Supreme Court ruled, as I understand, I'm not the department's counsel, but as I understand the Supreme Court's logic, it is a requirement upon the voter, and there's no language in the election code that instructs the county board of elections that they can accept a ballot if a voter forgets to enclose it in the secrecy envelope. So instead of eliminating it or creating another process, maybe we simply consider leaving it as a requirement, but giving the county board of elections instruction if a voter forgets to complete it, that alone cannot be a reason to reject the ballot or to set the ballot aside.
I'm a fan of Randall's idea of the deemed waiver. I think that's a great idea. I don't think you should have to check a box if you didn't do it. It can be deemed a waiver. If it's your right to privacy, and if you didn't do it, you waived it. Fine, but I like that idea.
We are only one of 16 states that currently use that secrecy envelope. So and it really does, I mean, we're talking about time and how long it takes and pre-canvas and all this. That, not having that other envelope cuts the time virtually in half.
I agree with Randall's comments. As I mentioned before, I'm not agreeable to getting rid of the secrecy envelope entirely, for what it's worth.
I believe it's in statute in at least a couple other places where for a jurisdiction that doesn't have the automation to do the extraction, which that automation can anonymize those ballots, jurisdiction that does it differently has to have a written plan and maybe a proof upon plan to keep those ballots secret. I mean, the folks who actually like have their hands on these envelopes and ballots and like have to extract them and flatten them, like is that a possibility? Is there a way to like, you know, extract these ballots and unfold them face down, for example, and have that's procedure that you and your staff go through? Again, we're assuming here there's actually one of these staff members who's actually interested in who people voted for when they're stuck in these offices doing this tedious work all day.
So Pat, one solution to that is in Snyder County, we extract the secrecy ballot first. Make sure it's not got writing on the secrecy ballot, and then put them on a stack by precinct, and then do them separately, the second ballot separately, so that you have no idea whose ballot is whose when you open the ballot and backfold it. So anonymity completely remains intact.
Pat, just a point for clarification. Many counties utilize two-sided ballots, so there's not really, I mean, there's sort of a front of the ballot which has the Board of Elections facsimile signatures on it, but they have votes on both sides most elections.
I'll just confess that as an occasional poll worker, before the law changed, I recognize my children's signatures on votes on their absentee ballots. So, they have distinctive handwriting, so I knew they were theirs, but I didn't tamper with them. So, but I understand where that was an issue because, especially in a small community and a small precinct like the one I live in, you could recognize a friend's handwriting or something like that. So, but yeah, I think we can try to come up with something that that incorporates what Randall was talking about, and see if some of our people who are more concerned, or that's not even the right word, who have concerns about not using the secrecy envelopes can feel reassured. So we'll see what we can come up with that would kind of address both sides of that issue. But yeah, but I do think overall that the automation now has, well, taking them out of the precincts has really been the biggest part about preserving anonymity, because you don't have your mom or your neighbor opening your absentee ballot and counting it at the end of the day. So
can I ask one more question related to pre-canvassing? Because I know there's a HAVA requirement, and I know state law requires ID to be sent for a first-time voter voting by mail. How does that fit in with the pre-canvassing? I mean, are people sending copies of their driver's license, or is the fact that they applied for a mail-in ballot using their driver's license or their social security number, is that counted as that ID requirement? I've never been able to get to the bottom of when that ID requirement fits into this whole process.
Yes. The answer is yes. The application.
Yes, what?
They either have to use their driver's license or the last four of their social as an ID requirement to apply for a ballot. Everyone has to, whether it's their first time or not.
But that's not the same thing as showing an ID to someone, an actual ID.
But it's entered into the core system, and it's checked that it's the correct number.
Okay, thank you so much.
I believe what the the statute requires right now is if you don't use the last four of the social first, if you don't have that, your driver's license number, or maybe it's the other way around. If you don't have either of those, you have to provide an approved form of photo ID. I believe it's not just photo or non-photo, but photo ID when you're applying for that mail-in ballot.
Yeah,
Hey,
that's
this is,
correct. It is driver's license first. If you don't have that, then last four of SSN.
This is Commissioner
And then
Lohr. I'm
the
sorry,
list
I'm going to have to
of-
jump off. We're doing bid openings for our new county prison. So I do apologize, but I'll see if I can catch up with anybody to get any information I missed. I apologize.
Thank you. Thank you. Yeah, I think what part of it, Representative, maybe I'm misinterpreting, is that I could give you one of my children's driver's license numbers and last four of their social because I know what they are. And when you show up at the polls, if we don't know who you are, we can look at that photo ID and say, oh yeah, that kind of looks like you. Your hair might be a different color, but that looks like you. And when you're doing that mail-in application, there's nobody comparing a photo to a face. Is that what I'm hearing?
Well, yeah. I mean, that's my concern is that there's this provision in the law that you need to show ID when you vote for the first time, at least in Pennsylvania law. And there's another provision in HAVA that requires that. And to me, providing a number rather than showing an actual ID or a copy ID, those are two different things. And I'm just not sure that actually comports with those statutory requirements. So, and I wasn't aware of how any counties were. I had actually meant to send a letter to my county to ask how they were handling that. I just didn't have a chance to ask anyway. So I thought this would be a good time to ask how that fits in to this whole pre-canvassing process.
And I think, Mr. Marks, were you gonna respond to that as well? I thought I saw.
Well, yeah, I was going to say that providing the driver's license number or the last four of SSN actually satisfies both the federal requirement and in this case the state requirement, which is different. It's actually more expansive than the federal requirement because it applies to all absentee and mail-in voters as opposed to some subset of those.
Okay. I don't want to give up time that we have unnecessarily. So are there other things generally about these issues that anyone would like to add?
Yvonne, when we were talking, just to go back to the pre-canvass timeline, the denumber of days, I know one of the things that CCAP has been pushing, our top two election reform priorities kind of tie together hand in hand. And I don't mean to muddy the waters, please understand me. And if this goes off the rails, I didn't start it. No, I'm just kidding. We'll just stop. But it's a legitimate concern. And part of the pre-canvass backup, like whether it's 7, 14, or 21 days, part of that conversation might need to be, when is the deadline for registration? Because I know that it's been talked about, CCAP has pushed for going from 7 to 15 days, in the same breath saying 15 days as a precursor for starting the pre-canvass. Coinciding those 2 days makes a lot of sense. So I'm just throwing that out there as a point of discussion.
Well, and I think from the responses we received on our initial survey, and please correct me if I'm wrong, anybody, that for the most part, people thought that registration period should end further away from Election Day than it currently does. So that verification of registrations, making sure everybody is or is not, that there was more, there was a desire to push that time back from where it is now.
even a decoupling of the deadlines between electronic applications and paper applications would be very helpful.
Just to clarify, Joe, I believe you're referring to, you said registration deadline, but I believe you mean the mail-in ballot and absentee application deadline, correct? Okay.
Correct. I'm sorry.
Oh, okay.
Right. Yeah, so we're just to keep things on track, but
Yes, make me think about voter registration.
Registration's 15 days presently. Application deadline for absentee and mail-in ballots is 1 week.
Okay.
And so we found in my prior county, when we thought the challenge was going to be to get poll books ready with the 15-day instead of 30-day voter registration deadline. And the reality very quickly became, as we were working through this, that no, we actually need to wait until after the application deadline in order to have poll books that have any kind of integrity that show who has requested a mail-in ballot, so those people aren't able to get a regular ballot at the polling place. And so we ended up with 2 different poll books the last 2 elections, November, primary in November. We try to find someone who is willing to do it and be able to turn it around fast enough in order to have accurate poll books that accurately show everybody who requested a mail-in or absentee ballot so that we can maintain the integrity of the process. Moving that deadline further out would potentially make life easier, but it will also create more emergency absentees. There are no emergency mail-ins, but it'll create more emergency absentees. And then counties are going to need to come up with a process to be able to handle ever-increasing numbers of those and maintain the integrity of their poll books. And that's just so we're aware. I'm not fighting CCAP on their wish there, but the reality of it is that we're also going to have to then we will absolutely see an increase in an expanse of emergency absentee ballots, and in many counties those numbers are fairly low numbers. As the 5th largest county, ours were substantial, but I can't begin to compare to Philadelphia or Allegheny, I'm sure, on those. But in many small counties, they're simply so small of a number as to not even be significant. But if you push that deadline to 15 days out, you're going to find those numbers are going to increase, and any move of that deadline should also include a process for those emergencies to be able to be accounted for at each and every polling place in a systemic manner. Because as you may have seen a comment I sent to everyone earlier on earlier discussion that I didn't speak on, but the more you can make this stuff routine for counties, the better it will work. The more it's a one-off, emergency, quick come up with something is it doesn't work as smoothly or as accurately as if you can make it part of the regular election routine for counties. And so any process to move the deadline up should also address how counties are going to handle this, what will become a substantial increase of emergency absentee ballots.
Makes perfect sense.
Recommend in the same vein, decoupling that deadline for mail-in ballot applications, whether from mail-in applications versus in person. So you can have the date closer for in person, but for the mail, obviously, longer.
Okay. I get that. Okay. Yeah, voter registration is another whole ball of wax we'll deal with another day. And again, from what we've looked at, it's everything from you can show up and register the day of election to you have to either, or you can register online or everybody's automatically registered. There's some really what some might consider some extreme proposals on voter registration, and we'll be bringing those as well as some more mainstream ones to your attention here in a future meeting. So,
Yvonne, when you talk about same-day registration, just so that everyone's on the same page, what that is a registration application submitted with a provisional ballot application in every state, as to keep that separate from a pre-registration world. But yes, they call it the same-day registration, but in reality, it's a provisional ballot submitted with a application which is kept separately, treated as a provisional, and not counted till it's verified that the registration is legitimate and can be processed. So I mean that is something, but I think we'll serve this group better if we refer to it because from an election administrator perspective, it's a very different world than either universal or whatever the deadline is. You create this. You put it this way: we can't do same-day registration in Pennsylvania with the staffing that we're currently allowed to have in a polling place per the election code.
Yeah, unless you want to see every other election director in the state also quit. We're just not. We're not.
They'll catch on eventually.
We're just not in an infrastructure place to even have that conversation right now.
Well, this seems like no burden at all. Come on now.
I saw one, there's been some that, like on your 18th birthday, you should be automatically registered. I mean, there are a lot of proposals out there that, as you termed it, Randall, a universal registration type proposal. So I don't see that happening in Pennsylvania, but we're certainly gonna give you the opportunity to say, no, we can't do that for whatever reasons. But there are some really aggressive proposals out there, both within Pennsylvania proposed legislation and in other states on that topic. So we're definitely going to probably spend a meeting or two talking about voter registration, but that's for another day.
Yvonne, along those lines, you should keep an eye on HR 1 in Congress because it has those provisions just like that. So yeah, depending on where, if anywhere that goes, we might not have any choice in some of these issues. So,
okay. Steve, did you catch that?
If you look at HR 1, it really bangs the drum for why we need electronic poll books. That will make all a lot better.
So Yvonne, one thing just for fun, just talk about unintended consequences, because I think that's always something this group needs to be aware of. When you, with your universal registration at age 18, so if you turn 18, you're automatically registered. What do many 18-year-olds then go do? Move off to college. Yes. Well, but that's not where they got automatically registered. And again, it's, yeah, anyway. But yeah, unintended consequences.
That's my kids. I mean, I'm not sure they've ever voted in person. They've done absentee ballots since they turned 18 because they've been at college for all of the elections. So yeah, it's an interesting, this is an interesting topic. That's why we're here, because there's so much to it. So before I forget, because I've already forgotten, I'm going to pull it up and look again. I asked Wendy when we should consider our next meeting, and I believe she said the best next date from her polling of all of you guys was June 10th. So I just want to throw that out there. We'll be in contact with you closer to that to firm that up, but that's the date right now we're looking at is June 10th. And I think the fallback would be July 8th, but I'd really like to this group get
Yvonne, I'd really like to do June 10th if we can make that work. I think we've got some momentum going here.
Yes, exactly.
And waiting till July. I think it would get worse by then and people start going away. Hopefully people are going away. But if we can make June 10th work, I think that's ideal.
Yeah, I absolutely agree. We become France in Harrisburg around July and August, and everybody goes to the Riviera because you can't find people to meet and do things because everybody's on holiday. So June 10th, yes.
Forgive me, Yvonne. This is Dan Vogler, and this, quite frankly, may only affect me out of all the county commissioners. But the 10th of June is a CCAP board of directors meeting day. But I don't know
the whole day.
Joe might. Yes, in fact, it's a Thursday and a. No, forgive me. I may have misspoke. That's actually I take that back. The CCAP meeting is Friday. They have a dinner on Thursday evening. So I apologize. I think the 10th would be okay. And I don't know if that, Joe, are you still part of the board? I believe you are.
I am, Dan. I don't have it on my calendar yet. Thanks for reminding me.
Yeah, I think that's the one they have in Butler County.
Yes.
But my recollection is, now that I think about it, the actual board meeting is the 11th. There's a dinner on the night of the 10th. So I apologize. So I think that would work.
All right, and would it be better if we had more of a later morning call than an afternoon call because of those potential conflicts?
I'll say selfishly, yes, but I'll respect the wishes of the majority.
Okay, well then we'll check and see what works best for most people, and take it from there. But yeah, no, I agree. I mean, the July 8th was really, if we couldn't get something in June, but ideally June would be much better to try to keep us rolling along. And on any of this stuff, is there something you want us to look at and include in what we're preparing on this for June 10th, please send it to Wendy. She's the best person to send it to, and then she'll get it to us and we can share as we go along. Chairman Lawrence, I'm going to turn it back to you. I have run through everything I got, so, and then some probably. So
I want to thank everybody. We've gone through a lot today, and I love the engagement. I want to thank the staff again for preparing all of this, but I think we're moving along in the right direction. So I appreciate it.
Good. All right. Anything else?
Do we need a motion to adjourn, or can I can just adjourn?
You know,
yes,
Steve. Steve's our rules person. He says yes.
Okay.
I was just going to interject.
Okay. Can I please get a motion to adjourn the meeting?
So moved, Mr. Chairman. So moved.
Right. And can I get a second? Moved by Mr. Smith. Can I get a second? Seconded by Senator Tartaglione. All those in favor?
Aye.
Aye. Those opposed? Okay. Meeting adjourned.
Thank you all so much. We'll talk to you soon.
Thanks all.
Yeah.